Okay, this is sort of the agenda. So what I'm going to talk about is give a definition for open data, big data, and then I'm going to talk about the benefits to the user. Following that, I'll talk about how we can use open data and big data with respect to quality and give some examples. Then I'm going to talk about patent value. What is patent value? Why do we want to look at it? And then the role of big data on patent value. And I'm going to talk about a project we're doing within the Office of International Patent Cooperation. It's an organization within the USPTO. So open data is publicly available, freely discoverable data that anyone can use, reuse, or redistribute easily. You see a link here. This is actually a link that external stakeholders can use. So it gives you the ability to actually look and do some analysis if you want to with regards to the open data. Big data is a collection of large volumes of data that can be mined for trends, patterns, and analysis. I think sometimes when first people see this, they think, oh, open data is completely separate from big data. That's not the case. There's a lot of information in open data. Obviously, it's publicly available, but it also contains some data which is actually collected in large volumes. It's not exclusive, but that is some of the items that we have in there. The things that are found in big data may not be found in open data. Specifically, we do have some issues more for performance management that we look at the USPTO, more specifically, for instance, for quality of the examiner. So that sort of gives you the background as to the differences and what is open data and big data. In terms of overview, what are the benefits? As mentioned, we have a portal to improve the accessibility and usability of the public patent data, but we also established a developer hub, which provides a shareable and social platform for anyone in the community to use. So what's the benefit of this is that you can actually use it as a stakeholder with any of your other external stakeholders. You can also use it in conjunction with any databases that you have. Like for instance, if you have something on geographic location, you can use that in conjunction with the information that we have. The other thing it allows you to do is if you think there's anything that we can do to improve within the USPTO, we welcome those type of comments because we'll use that feedback as a basis to see what we can actually do to even foster a more powerful cooperation between the external stakeholders and ourselves. So I think one important point that I would like to emphasize, it's not the amount of data that's important, it's what the organization does with the data. I mean, we can provide as much data as possible, but really what the benefit is the people are actually using it. So now what I'm going to do is, how do we use the big data to improve patent quality? And I think it sort of touches upon, I think the previous panel is, like for instance, training. We can actually look at the impact on training. One of the things that I would say sometimes we actually had a tendency to do perhaps is just provide a survey, which actually is good because it gives immediate feedback on that training. But one of the things we're also looking at is there an implementation of the training that we actually provided to the examiners? So what we can actually do is we can use big data to see how effective that training was 6 months down the road or even a year. So for example, let's say you have a training on identifying subject matter early in prosecution. You can actually look before the training to see what is that frequency of identifying it. But you can also look at it at later stages. So that gives you the ability to actually demonstrate and determine the efficacy of that training. I do want to mention, and I was talking to some people after the break, is that our training is available online. If for some reason you think there's a situation that, when you see examiners, they're talking about some training that isn't, I would suggest, maybe perhaps talking to the manager, the quality assurance specialist within that technology center. We also have an ombudsman program, so they can actually assist you in that. But again, what I would emphasize is that our training should be available to the public. The other one, and I'm not going to go through all of them because of time, we can also look at it as to validate assumptions. And I'll go back to the identifying allowable subject matter early. I think the assumption would be that your senior examiners, those examiners that are primary examiner is one that has the ability, authorization to allow cases are they actually allowing cases or providing the reasons for allowance early at a higher frequency than a junior examiner? A junior examiner perhaps is someone here for 1 or 2 years. So we can actually use big data to actually filter those cases. I think the one thing I want to stress is that big data is not the end all. It can actually just causes a filtering. You actually have to look at the cases to see also to determine if it's what you're asking big data to do, is it actually delivering? And it allows less manpower, because if you had to do that filtering as with a group of people, it's going to take a lot of time. But by having the big data, it gives that first screen. And then after that, you can actually look at it yourself as the manager. Patent value. I thought this was a great quote. It was from Darren Tang. He's the chief executive of the Intellectual Property Office of Singapore. It's in regards to how he looks at patent value. To some external stakeholders, I would say specifically the small inventors, and to the public as a whole, IP offices talking about IP on a legal standpoint is a manner in which they don't understand. So part of the change we need to address is changing the way we talk about IP to these type of stakeholders and to the general public. And I thought these quotes are really telling, so I'll just leave it on there for a minute or so, just if you want to read it. But I thought it was very interesting. So what are the factors which help define a potential value of a patent? The way I look at it is there's 3 factors. There's the quality of the patent, the legal defensibility, and the economic impact. So all 3 are the drivers. It can't be, the way I look at it, it's not a situation that you can just have one and not the others. So for instance, let's say you have a patent of high quality. Well, you might have a situation that claim, let's say it's a situation where you have one claim in a patent, it can be so very limited in scope that it really may not have any economic impact. So I think what you have to look at is all 3 factors in looking at the potential value. What is the role of big data? And I think I sort of alluded to this in terms of the quality, but it's also for the value of the patent. It's for filtering and prioritizing which patents to examine more closely for potential valuation of a patent. It provides efficiencies that enable to make decisions in a faster and a more qualitative manner. So what I want to talk about, it's in the next couple of slides, is a project we just started within OIPC. What we first of all looked at is what are the indicators in a patent value? And I think yesterday there was a panel that was talking about it. These factors are more in the context of, I would say, of a patent itself, not of the collection. So what we can look at is, and this is what has been found by other investigators, one of the things that actually shows potential for a patent value is the frequency of backward citations. That is, how many citations were referenced in that patent that was issued, and also the forward citations. How many times is that patent actually cited in other applications or other patents? The other situation is patents which are upheld in opposition, and patents that represent large international patent families. This is just a limited number. There's a whole bunch of other examples, but I just wanted to give you a flavor of what actually, some of the things that would indicate patent value. So what we did is we started looking at inter partes reviews. This is in Europe, it would be similar to an opposition. So what we did is we looked at some of the characteristics that other investigators have found with patent value to see, do we find those similarities within the IPR cases? And we found 2 things that seem to be found now, and this is just preliminary because we just started a couple months ago. So one of the things we're finding is that they have a high number of references to the patent literature and non-patent literature. Oh, I'm sorry, to the non-patent literature. So it's more the NPLs. Also, we find a higher number of related applications. And what I mean by this is we find a higher frequency of continuations, CIPs, divisionals, and RCEs. So you might, before I go on a little further, why are we looking at inter-party reviews? Well, we're looking at those inter-party review cases that have actually been found patentable after being reviewed by the board. So we're looking at only those cases in which they found all the claims to be patentable. So I think it fits one of the criteria in terms of what I was talking about with regards to patent value, specifically that of quality. So that's the reason why we're actually looking at this. Our goal ultimately is to see what we find as indicators of high patent values in inter-party reviews is what is found in regards to those cases which we're actually looking at in the international arena. So what I mean by that is, for instance, in the OIPC, the Office of International Patent Cooperation, we have programs with work sharing. And what I mean by that is trying to bring to the examiner not only the references that they find, but those references that we find from examiners from other IP5 countries, for instance, JPL, IIPLA, or any other offices that want to join into that program. So what we want to do is to see if those factors that show an indication of patent value, are they transferable not only to the IPR cases, but also these programs that we are conducting in OIPC. The reason why we want to do that, it fosters more information to attorneys and inventors to see, do they want to actually participate in these programs? So it's providing that information, and I think it helps them to get a better understanding and then see if they actually want to participate in those programs. So that's pretty much where we just started, and we're going to be continuing this program, but that's just I wanted to give you sort of an introduction to what we're looking at in terms of a project. So a couple things is, if you have any questions, here's my email address. If you have any general questions, here's the general email box for that. The other thing I just want to mention is I mentioned some of the work sharing programs. I have some brochures that are on the table. So if you go outside, if you want to look at our work sharing programs, I have some information there. Also, I think in your booklet, I think on page 40, it actually talks about some of the programs we're actually doing within OIPC. So again, if you need any more information, those are two resources, or if you have any other questions or if you want any other further information, either email myself or the general email box. So thank you.